Welcome to Module 4 Key Concepts lecture. In Module 1, we were given a cursory introduction to the main constitutional and federal laws applicable in corrections. Today, we're going to go a bit further in our learning about how the courts have applied the Constitution to uphold, or not, the rights of inmates. As a brief refresher, we have three amendments that are largely relied upon when it comes to corrections. The Eighth Amendment, which is the right prohibiting cruel and unusual punishment, the 14th Amendment, the right to certain procedural safeguards during hearings, and the First Amendment, freedom of speech and freedom of religion. We will also look at how the Fourth Amendment, the right against unreasonable searches and seizures, applies to those who are incarcerated within a correctional facility. To start with, we'll talk about the Eighth Amendment. The Eighth Amendment states, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. This is the amendment that prohibits cruel and unusual punishment. It is a cornerstone for advocating for humane conditions and fair treatment within correctional facilities. We also rely on the Eighth Amendment to prohibit correctional officers from using excessive force against inmates. But, as we'll see, in the case law, the Eighth Amendment is a pretty low bar. The standard that the courts will look at is whether correctional officers exhibited a deliberate indifference to conditions presenting an excessive risk of harm. What does that mean? Well, let's dig in a bit deeper by talking about one of the assigned cases from your readings this week, Wilson v. Sater, a Supreme Court case from 1991. In Wilson, an inmate sued the prison authorities where he was housed in Ohio for issues related to overcrowding, excessive noise, insufficient locker storage space, inadequate heating and cooling, improper ventilation, unclean and inadequate restrooms, unsanitary dining facilities and food preparation, and housing with mentally and physically ill inmates. He sued in part under the Eighth Amendment's prohibition on cruel and unusual punishment. This was a great case for us to read, as it does a nice job summarizing the prior case law on this topic. The court states, with the standard that it employs when evaluating whether there was a violation of the Eighth Amendment as explained in the prior case of Estelle v. Gamble, the standard is inflicting unnecessary and wanton infliction of pain, or rather, deliberate indifference. In Estelle, an inmate filed suit arguing that his doctor's failure to treat his medical needs was a violation of the Eighth Amendment. In that case, the court disagreed. The court said there is no Eighth Amendment violation because the doctors did not have a sufficiently culpable state of mind. The court explains this standard was first enunciated in another case where an inmate was subjected to a second attempt at electrocution after there was a technical malfunction with the chair during the first attempt of electrocution. The court said there was no violation of the Eighth Amendment. The first attempt had been thwarted by an unforeseeable accident. It was a technical issue with the chair, so that the officials lacked the culpable state of mind necessary for the punishment to be regarded as cruel. After the Estelle case, the court also heard arguments in Rhodes v. Chapman to determine whether an inmate's Eighth Amendment right was also violated. In that case, two inmates were bunked up in a single cell, a practice called double celling. The court said that this also did not amount to cruel and unusual punishment. Perhaps it inflicts pain, but not cruel and unusual punishment. The court elaborated and stated that the Constitution did not mandate comfort within prisons, and that a violation of the Eighth Amendment would arise only by denying the minimal civilized measure of life's necessities. Here, the court notes that the test for an Eighth Amendment violation actually has two prongs. First, an objective prong, where we ask, was the deprivation sufficiently serious? Second, a subjective prong, where we ask, did the officials act with a sufficiently culpable state of mind? A deliberate indifference could be enough for a sufficiently culpable state of mind. The court again heard and rejected an Eighth Amendment violation argument made by an inmate who was shot by a corrections officer during a fight in the prison. The court said no, not an Eighth Amendment violation, because it must involve more than ordinary lack of due care for a prisoner's interests of safety. It is wantonness, not inadvertent or error in good faith. Rather, you need the wantonness. An inadvertent or error in good faith will not amount to a violation of the Eighth Amendment. The court does agree that you don't need just one condition to have a violation of the Eighth Amendment. You can look at the bigger picture, or rather, an aggregate of a bunch of different issues arising within the correctional facility. Ultimately, in the William v. Sater case, the court does not decide at all whether the inmate in this case had his rights violated by the Eighth Amendment. Instead, the court says, now that we've better explained the test, the lower court can decide whether the inmate's right was violated. Meaning, so that when an inmate initially files a lawsuit, he starts with the lowest court. And then at some point, it gets appealed to, say, the intermediate court. And then from that court, it can go up to the Supreme Court. And so after the Supreme Court has decided the hard issue of what this test for the Eighth Amendment actually is, it then got sent back down to the lowest court to decide and look at the facts. Did the facts in this case, as alleged, and again, they could look at the big picture of all of the different factors together. Are all those factors together a violation of the Eighth Amendment? And the lower court in this case found that nope, even with all these factors looked at together, there's still not a violation of the Eighth Amendment. In terms of excessive force, as used by correction officers, we also look to the safeguards imposed by the Eighth Amendment. The court will look at factors such as extent of injury, the necessity of force, and whether force was used in good faith effort to maintain or restore order. The courts will ask whether the force was reasonable from the perspective of a reasonable officer on scene. This standard is objective, and the court's basically going to ask, what would a reasonable corrections officer have done in that same situation? And the court's going to give a lot of leeway to the corrections officers here because hindsight's always 2020. So they don't want the officers second guessing themselves too much when they have to make a spur of the moment decision in order to make a decision that will benefit the majority of the well-being of the inmates as opposed to one inmate's well-being, if it was more important to use whatever force necessary to restore order in the correctional facility. And so that's why they end up giving the corrections officers a lot of leeway, and they just use this test, this objective test here of what a reasonable corrections officer would have done. In addition to the Eighth Amendment, we also have the 14th Amendment to provide some constitutional safeguards. The 14th Amendment states, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law. The key language here for us is deprive any person of life, liberty, or property without due process of law. This is called the Due Process Clause and ensures that inmates are given due process before life, liberty, or property is taken away. Now, so those things can be taken away, life, liberty, and property can be taken away, but in order to be taken away, certain procedural safeguards must be first followed to give the inmate an opportunity to present evidence and be heard by an impartial decision maker. We often see this right at play with parole board hearings, disciplinary hearings where the inmate is facing serious consequences, and providing access to legal resources to ensure meaningful access to the courts. In the assigned prep work for this module, we had a video from the New Yorker about going before a parole board hearing in the state of New York. For these individuals in New York, they were given a range in their criminal punishment, say for instance, 15 years in prison to life in prison. 4 months before the earliest date of release, a hearing with the parole board is scheduled. Board interviews should include questions about prior criminal activity, custodial record, program participation, future goals, and release plans. They are supposed to take place before an impartial decision maker. The offender at the hearing has the opportunity to speak and present evidence. No attorney is provided for the inmate, but of course the offender may always hire one. Victims also have the right to be heard either in person or they can submit a written opinion on whether the offender should be released. The parole board must issue a written notification of its decision within 2 weeks of the offender's interview. If parole is denied, then the offender has an opportunity to appeal the decision. And in the video, if you recall, they talk about seeing how thick the envelope was. If it was thicker, then that meant their parole had been denied because there was appeal paperwork within the envelope. And for me, it reminded me of getting my college admissions acceptances in the mail, always checking to see how big the envelope was, which would tell me if I was accepted or denied. Um, though I, of course, admit college acceptances are much different than dealing with a parole board. If the parole is granted, the board then determines the release date and conditions for supervision. As the video highlights, we see this inherent tension between the goals of punishment and rehabilitation that we've been talking about throughout this course. Some of the offenders completed all of their rehabilitation conditions very early in their incarceration and finished meeting the punishment goal with the rest of the time spent in the correctional facility. So they did the rehabilitation while they were incarcerated and then just were incarcerated for a number of years as they fulfilled that punishment goal. But then the parole board at that point is left to decide whether punishment is more appropriate, whether more punishment is appropriate, and whether the board thinks the offender may still be a danger to society. What's the likelihood of this offender's recidivism? It's not a mathematical formula. We don't have one that can be established by the research. It's a very person specific inquiry, um, or rather a case by case determination. And inmates are also entitled to procedural rights when facing serious consequences at a disciplinary hearing, such as solitary confinement. And going back to the parole board hearing, we saw all those procedural safeguards being applied. We saw that they were given notice 4 months before their earliest release of when their parole board hearing would be scheduled. They then went before the parole board, and you heard each person that was interviewed had the opportunity to speak, if only for a few minutes, but still had the opportunity to say something. Um, and then they were allegedly in front of an impartial decision maker, and then they were given notice of what happened and the opportunity to appeal afterwards. It did seem like from the video that the cards were stacked against each of the inmates, though, because there was a default. Well, there was kind of an assumption that all of these inmates, because of the heinous nature of their crimes that they were initially incarcerated for, made them still a danger to society, no matter how much rehabilitation or how many programs they had participated in while they were incarcerated. And then we kind of heard that New York started to change who was being appointed to be these impartial decision makers, and that there was a small shift in the decisions, and that more inmates were being released and given parole. And so we see these same kind of procedural safeguards when we talk about disciplinary hearings where the inmate is facing a serious consequence, such as solitary confinement. And in these hearings, the inmates too are entitled to timely and specific notice of the charges and basically the charges, whatever disciplinary behavior they had engaged, or whatever behavior they engaged in that is being subject to discipline, or that the correctional facilities want to impose a punishment for. They're entitled to the notice of those charges. They're entitled to the opportunity to present witnesses and evidence, and to a fair hearing conducted by an impartial decision maker. But as we read, it can be difficult for an inmate to gather evidence all by themselves when it's difficult to communicate with the other inmates who may or may not have been witnesses to the incident. Nevertheless, those are the procedures that the 14th Amendment requires. And again, like the Eighth Amendment, it's a pretty low bar. And we can also see that these same safeguards are triggered when a transfer decision is being made if the transfer poses an atypical and significant hardship on the inmate. In that case, the inmate would be entitled to a meaningful opportunity to challenge the transfer. Certain factors that might make it atypical or significant hardship might be access to a program, safety, and family connections. The transfers should not be punitive, nor should they be arbitrary. And just as we discussed earlier with the Eighth Amendment, courts will afford corrections a lot of latitude here too, so that they may ensure safety within the prisons and in the general public. And one of the other reasons why such wide latitude is given to the corrections officers is that the judges are not on, they're not there when the officer has to make the decision. So they don't want to come in with this, well, I know everything that happened because you made that decision now, and here's what you should have done. They want the officer to make the best decision that they can under in the circumstances without the fear of having everything go before a court. Another constitutional safeguard we have for inmates is found in the First Amendment that addresses both the right to practice religion and the right to speech. The First Amendment states that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people peaceably to assemble and to petition the government for redress of grievances. So the amendment affords individuals some protections to practice religion without government interference. It also ensures individuals have space to express opinions and ideas without government censorship. And here the government is correctional facilities, or the correctional officers. And these rights are clearly not absolute. And they're not even absolute, as we know, for those outside of prison. But they are more constrained, even so, when incarcerated. Because again, courts want to protect the correctional facility's ability to keep incarceration facilities safe. These facilities, though, are expected to include opportunities for religious worship, access to religious materials, and reasonable accommodations for religious practices. Facilities are required to accommodate religious beliefs unless there is a compelling state interest. Again, the test for that is it, these resources and options are expected to be provided for inmates unless there is a compelling state interest. And in these cases, the court doesn't always side with the correctional facilities. For example, facilities are required to allow their inmates practicing the Muslim faith the opportunity to grow a beard in accordance with religious practice. We read about a certain case where an inmate converted to Islam while in custody. He sought permission to grow a half beard while incarcerated, and corrections denied his request to grow the beard, citing security concerns, such as it might be a place to hide contraband. And we have a picture of this particular inmate here. The court said inmates are allowed to grow hair on the heads, and inmates are allowed to wear clothing, both of which would make a plausible place to hide contraband. Nevertheless, prisoners are not required to go about bald, barefoot, or naked. So the court ultimately held that the half-inch beard did not present a sufficient security concern. Inmates should also have avenues for non-disruptive expressions of opinions and grievances, for the First Amendment's right for freedom of speech. Communication wise, facilities often regulate an inmate's exposure to books, newspapers, and other media, and certainly the ability to communicate both with individuals outside of the facilities and within the facilities. That communication is regulated very heavily. But the restrictions on inmates have been hotly contested in other areas that we might not have initially thought of, such as artistic endeavors, and whether an inmate can profit from such artistic endeavors. The Marshall Project article detailed some of the struggles faced in this arena, with inmates from profiting from creative outlets. For instance, the podcast produced in a prison in California called Ear Hustle. One inmate actually produced an entire opera that was performed at Carnegie Hall, and another inmate wrote a novel called Cherry that was later adapted into an Apple TV film. The state of New York decided that inmates should not profit from these sales and that the money should instead go to the victims of the crimes and to their families. On the one hand, we can understand that we don't want inmates to make a profit from their unlawful and potentially heinous conduct. We want inmates to be focused on rehabilitation and serving their punishments, and we want victims to be able to tell their own story and made feel whole without feeling like they're being taken advantage of as the inmate makes a profit from the actions. But on the other hand, these are the stories of the inmates. It's their lives too, and they have a right to express their own life experiences. And perhaps it's a bit healing for them too to retell their story in an artistic endeavor. Courts have responded by saying that correctional facilities must be able to articulate a security concern in order to censor these paid expressions. And here we have an image of the individuals responsible for the Ear Hustle podcast that is still ongoing as the time of this podcast, as this lecture is recording. And then um, a, a graphic image, I guess you would call it, of the inmate who wrote the opera that was performed at Carnegie Hall, and then an image of the Cherry novel written by the inmate. So now let's talk about how the Fourth Amendment plays out in correctional facilities. The Fourth Amendment is the right against unreasonable searches and seizures. Again, this is not an absolute right by any means. It's not a right to be free from all searches and seizures. In fact, even when you're not incarcerated and you're just out in the general public, as we know, it's we the general person does not have a right from any search and seizure. It's a right against unreasonable searches and seizures as defined by the courts as to what's unreasonable. The text of the Fourth Amendment reads, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." So the second half of that text is talking about what requirements a judge needs in order to issue a warrant. And the part that's most relevant for our course discussions is the part that's been underlined, the part that says there's a right to be free from unreasonable searches and seizures. Well, how does this play out in a correctional facility when there is a heightened need to ensure safety and order? Well, of course, there's a balance, as we've seen with the other three amendments that we've discussed in this lecture. When it comes to a search, courts often ask whether the individual had a reasonable expectation of privacy to the area being searched. In prison, it's understood that inmates have a reduced expectation of privacy within their cells as opposed to a non incarcerated person. Correctional officials are within the law to conduct routine cell inspections without the need to have any suspicion of any wrongdoing. These searches are considered a necessary tool to uncover contraband and ensure safety within the facility. A step up from the cell search is the strip search, where officers are required to actually have some suspicion. In fact, they're required to have a compelling justification due to the intrusive nature of a strip search. That said, corrections is allowed to strip search all arrestees when they're first entering the jails. And that makes sense because you're coming from the general public, you're in your normal clothes, you have to get changed into the jumpsuits that the correctional facilities require you to wear. And as they're going to do that, they're going to check your body to make sure you're not bringing any other contraband into the jail. But in addition to these security and contraband concerns, the courts have upheld these intrusive searches as also serving a medical need. So it's not just security, we're also going to look at medical needs for the searches. Because if a medical issue such as lice is uncovered, then the inmate will need to be separated and treated so that we don't have a lice problem that spreads to every inmate within the correctional facility. And it is important to note, though, that different jails have different standards of a strip search. Some facilities are fine with limiting the search to just wearing clothing, while others require more thorough inspection. All inspections, however, as mandated by the courts, must be conducted in a professional manner that does not intentionally humiliate the inmate. As you can imagine, that might be hard to prove in court, the intentional humiliation, but that is the requirement. And then we have one step up from the strip search, which are body cavity searches. And this is the most intrusive form of a search that can take place from the Fourth Amendment point of view within the correctional facility. And here, the officers need specific and credible information indicating that the individual possesses contraband. Generally, they need to go get a warrant, or there must be some exceptional circumstances that are required to justify a body cavity search. It remains to be seen what courts will require with regards to the advancement of monitoring technology as the courts balance the need for safety and order with an inmate's right to be free from searches and seizures. And here we're talking about the use of video cameras and monitoring the inmate's actions, every little action on a day-to-day basis, and how intrusive can we get with the technology. And while these rights are fundamental, and these rights being the First Amendment, as we discussed, the Fourth Amendment, the 14th Amendment, and the Eighth Amendment, their application within correctional settings, as we've discussed, is nuanced. Courts recognize the need for reasonable restrictions to maintain security and order while balancing individual liberties with institutional concerns. Understanding these legal precedents is essential for our policymakers, correctional staffs, and advocates so that we can ensure that inmates' rights are being protected while also ensuring the safety. And that's it for those Fourth Amendments, and as it relates to our studies on constitutional law within correctional facilities. So, for your study guide this week, be sure to understand which amendments apply to the correctional settings and how they apply. With regard to the Eighth Amendment, you should understand and be able to articulate the two-pronged test used by the courts to evaluate cruel and unusual punishment claims. You should know how it played out in the fact patterns that we discussed, and how a court might apply the test in a similar fact pattern. From the 14th Amendment, you should understand which procedural safeguards inmates are entitled to during certain hearings, such as the parole hearing and disciplinary hearings with serious consequences. You should know what the standard is for an inmate being transferred. From the First Amendment, for the First Amendment, you should know how courts balance security concerns with the right to speech and practice of religion. You should know the fact patterns that were mentioned in the rationale. And then for lastly, the Fourth Amendment, you should understand how the standards for searches becomes more difficult for corrections to meet as the search becomes more intrusive. You should know that inmates have a general reduced expectation of privacy as opposed to someone who is not incarcerated, and therefore inmates do not have the same rights as those in the general public. All right, and on our next Key Concepts lecture for Module 5 will be our last Key Concepts lecture for this course. Best of luck.